Hello everybody and welcome to the Students' Verdicts Halloween episode. Tonight I'm going to tell you a horrifying story. The scariest part is that it's all true. Our story starts on Halloween of 1979 in Southern California. On this night, two serial killers, Lawrence Bittica and Louis Norris, abducted their fifth and final victim, Shirley Lynette Ledford. The pair had kidnapped, raped, tortured and killed 5 teenage girls over a period of 5 months. They would become known as the Toolbox Killers because the instruments they would use to torture their victims were items that you would normally find in a household toolbox. Before we delve into this story, I need to warn you that this episode contains graphic details of sexual assault, suicide, torture, and murder. It's not suitable for all listeners, and listener discretion is therefore strongly advised. If you like the show, please consider leaving us a review. If you don't like us, then please keep your comments to yourselves. Our main sources for this episode are Wikipedia and Find Law, both of which are linked in the show notes. Please check there for a full list of resources. Before we start the episode, a quick reminder to listen to our Rob Knox 3-part special, where I collaborated with True Crime Fix and Lady Justice podcast to bring you one man's incredible story. We discuss who Rob Knox was, beyond him just being an incredible actor who starred in Harry Potter. We talk about the night he died, the trial of his killer, and the legacy he has left behind. There are a couple of exciting things to also tell you. The first, which I am super excited about, is the launch of the Students' Verdict merchandise. We're doing t-shirts, hoodies, sweatshirts in all different colours with the new logo. Perfect for this spooky season. I'll include a link in the show notes for you to check it out. If you do buy anything, please tweet me a picture at Student Verdict, tag me on Instagram at the Student Verdict Pod, and on the Students Verdict Podcast's Facebook page. The other thing to tell you is that we are now on Patreon. If you'd like to support the show, we have 4 tiers ranging from £3 to £20 a month. You can find the link to our Patreon page in the show notes. Each tier comes with a variety of perks, from a shout out to bonus content. So please check it out. Any support is hugely appreciated. Just a heads up before we start, this is going to be a long episode. So honestly, I'd go and grab yourselves a drink and some snacks. I'd get some comfy clothes on. You've been warned. Now, let's get on with the episode. I'm going to start this episode with a quote from Joe Hill's novel, Horns. Maybe all the schemes of the devil were nothing compared to what man could think up. Our Halloween tale begins with 2 babies, Lawrence Bittica and Louis Norris. Lawrence Sigmund Bittica was born in Pittsburgh, Pennsylvania, on the 27th of September 1940. His birth was not well received, as his parents had chosen to not have children. As an unwanted child, he was put into an orphanage and was later adopted by a couple, Mr. and Mrs. George Bittica. It's reported that George Bittica, Lawrence's adopted father, worked in the aviation industry. Because of the nature of his father's work, the family was often uprooted and moved around the US, which didn't really allow Lawrence time to settle anywhere for very long before the family would move on again. Louis Norris was born in Greeley, Colorado on the 5th of February 1948. His conception came as a surprise. He was conceived during a time when it was frowned upon to have a child outside of marriage. Norris's parents therefore quickly married to avoid the social stigma. It was more of a marriage of convenience rather than love. Norris moved between living with his parents, his father a scrapyard worker, and his mother a drug-addicted housewife, and foster care. From young ages, both Bittica and Norris displayed concerning signs. Bittica first became known to police when he was just 12 years old, when he was arrested for shoplifting. And this was just the start. He went on to build up a bit of a criminal record for himself over the next 4 years. He was arrested for shoplifting again and petty theft, which got him involved with the juvenile authorities. Bittica would later claim to have committed these crimes to compensate for the lack of love he received from his parents. Norris was extremely troubled. He reported having been neglected by his own biological family and by many of the foster families he was placed with. He claimed to have been denied sufficient food and clothing. He also claimed that he was sexually abused while staying with one of his foster families. When Norris was just 16 years old, he visited the home of a female relative, who was, at this time, in her 20s. He began speaking to her in a sexually suggestive way, which made her really uncomfortable, so she told him to leave. She notified Norris's father, who threatened his son physically. As a response to this, Norris stole his father's car and drove into the Rocky Mountains, where he attempted to commit suicide by injecting pure air into an artery in his arm. He was later apprehended as a runaway and was returned to his parents, who welcomed their son back with open arms by saying that he and his sister were unwanted and that they would be getting a divorce when both children reached adolescence. A year later, Norris dropped out of school and joined the US Navy. He was stationed in 1965 and was deployed to Vietnam in 1969. He didn't see active combat during his tour of duty and was honorably discharged from the Navy after one tour of duty. Bittica, who was reportedly very smart with an IQ of 138, was bored of school and dropped out of high school in 1957. Within a year of dropping out, Bittica was arrested for hit and run, car theft, and evading arrest. He was sent to the California Youth Authority, where he remained until he was 18 years old. Upon his release from this institution, as with Norris, Bittica was not welcomed back by his adoptive parents, who had actually disowned him and had relocated to another state altogether. He would never see his adoptive parents again. So let's delve into their criminal history. Shortly after Bittica was released from the California Youth Authority, he was arrested again for transporting a stolen vehicle across state lines. He was sentenced to 18 months imprisonment in August 1959 and was sent to the Oklahoma State Reformatory. During this sentence, he was transferred to a medical center for federal prisoners in Springfield, Missouri, where he served the remainder of his time. Bittica was released in 1960, but was soon back to his old ways, committing crimes. Within months of his release, he was arrested for robbery in Los Angeles, and in May 1961, he was sentenced to 15 years imprisonment. While serving this sentence, he was diagnosed by a prison psychiatrist as being highly manipulative and having, quote, considerable concealed hostility. So, jump forward to 1963. Bittica is released on parole, having served only 2 years of his sentence. By October 1964, however, he's back inside again for a parole violation. Bittica underwent further examinations by 2 psychiatrists who both classified him as a borderline psychopath, echoing what the first psychiatrist said, which is that Bittica was highly manipulative and was unable to acknowledge the consequences of his actions. He was prescribed antipsychotic medication. Bittica had told the psychiatrists that his crimes made him feel important and that circumstantial matters pertaining to his environment and upbringing meant he couldn't resist committing crimes. A year later, he was released again. It's 1967 now, and a month after his release, Bittica was arrested again for theft and for leaving the scene of an accident. He was sentenced to 5 years but only served 3 before being released in 1970. Roy Norris was arrested for his first sexual offence in November 1969. He was charged with rape and assault with attempt to commit rape, resulting from 2 separate incidents. In the latter incident, Norris had attempted to force his way into the car of a lone woman. In February 1970, Norris tried to trick a woman into letting him into her home. She refused, so he attempted to break into her house, causing the woman to phone the police. Thankfully, the police arrived before Norris got the opportunity to hurt the woman. Less than 3 months later, Roy Norris was diagnosed by military psychologists with a severe schizoid personality. This type of personality is characterized by a lack of interest in social relationships, a tendency toward a solitary or sheltered lifestyle, secretiveness, emotional coldness, detachment, and apathy. Because of his quote-unquote psychological problems, that's how the Navy worded it, Norris was given an administrative discharge. In May 1970, Norris, who was on bail at this point, attacked a female student from the San Diego State University whom he had been stalking. Just to warn you, this next part is pretty graphic. He struck the woman on the back of the head with a rock. He did it again and again until she slumped to her knees. He then repeatedly beat her head against the sidewalk whilst kneeling on her back. Norris was later charged with assault with a deadly weapon and was sentenced to 5 years imprisonment. He was to serve this at the Atascadero State Hospital, where he was classified as a disordered sex offender. By 1971, Bittica, who had only been released the year before, was arrested for burglary. For this offence, Bittica served 3 years before again being released. It was in 1974 that Bittica committed his worst offence so far, when he stabbed a supermarket employee who had accused him of stealing. It's reported that the supermarket employee had seen Bittica steal a steak, so followed him outside into the shop's car park. He politely confronted Bittica by asking whether he had forgotten to pay. Bittica then stabbed the member of staff in the chest before trying to flee. He was wrestled to the ground by 2 other supermarket employees and was arrested for assault with an attempt to commit murder. I'm very happy to say that Gary Louis, the victim in this case, did indeed survive the attack. Bittica was convicted of a lesser charge of assault with a deadly weapon and was sent to the California Men's Colony in San Luis Obispo. Roy Norris was released from Atascadero State Hospital in 1975 with 5 years probation. Apparently, doctors declared Norris as an individual who was of, quote, no further danger to others. How wrong they were. 3 months after his release, Norris tried to convince a woman to have a ride on his motorbike with him. When she declined his offer for a lift, Norris grabbed the 27-year-old's scarf, twisting it around her neck. As he did so, he told her he was going to rape her before dragging her into some bushes. The woman later said that she did not resist the rape in the hope that she would survive the attack. It wasn't until 1 month later that the woman saw the same type of motorcycle. She knew police had been unable to find her attacker, so he was out there. Then she noticed the number plate. It was the same motorbike. She gave the number plate to police, and Roy Norris was arrested for rape. He was tried and convicted 1 year later and was sent to the California Men's Colony in San Luis Obispo. This is where the lives of these 2 men collided. They didn't become acquainted straight away. In fact, it wasn't until around a year into Norris's sentence that he and Bittica became aware of each other. It's said that Bittica's initial impression of Norris was that he was savvy a man who was largely associated with hardened criminals, guys who dealt drugs in prisons and were in motorcycle gangs. Norris and Bittica actually became close friends after Norris taught Bittica how to construct jewelry. I mean, how innocent is that? They met making jewelry and then went on to commit some of the most horrific crimes imaginable. Their friendship was sealed when Bittica saved Norris from being attacked by another inmate on at least 2 occasions. That friendship that started with making jewelry took a very dark turn in 1978 when the pair realized that they shared a common interest. I hate calling it that, but that is what it was, an interest. Bittica and Norris had a shared interest in sexual violence and misogyny. Norris confided to Bittica that his biggest turn-on was seeing a frightened young woman, hence why he had committed so many sexual offences in the past. It's said that although he'd never been convicted of any sexual offences, Bittica had considered raping a woman and had determined that he would have to kill her after, so as to not leave a witness. It was from here that the two began to hatch a deadly plan to assault and murder teenage girls once they were freed and back in society again. This was such a sick plan. They planned to murder one girl of each teenage year from 13 to 19 years old. All they had to do now was wait until they were both released and then meet up on the outside. It didn't take long before Bittica was released on the 15th of October, 1978. It actually seemed like Bittica was going to do really well on the outside. He found a job as a machinist, which earned him a good wage of around $1,000 a week. And he began making friends with people in the neighborhood who considered him to be generous and helpful for his donations to the Salvation Army. On one occasion, he bought loads of fast food and wine, which he distributed to the homeless community in downtown Los Angeles. It's a bit weird, but Bittica was popular with teens as he'd drive them to his place where he'd provide them with beer and marijuana. Norris was released exactly 3 months after Bittica on the 15th of January 1979. After his release, he moved to his mother's home in Redondo Beach and soon found employment as an electrician in Compton. It all seemed to be going okay. That was until a letter came through Norris's door. In late February, the pair met at a hotel and rekindled their monstrous plan. The first step of this plan was to get a vehicle. The pair had worked out that a car wouldn't meet their needs and that a van would be better. In order to carry out the attacks, they wanted a vehicle that had a large passenger side sliding door and no windows. With such a door, they could pull up close to their victims, slide it open, and drag their victim inside. Bittica and Norris nicknamed their van Murder Mac. The next thing the pair planned to do was practice. Between February and June 1979, Bittica and Norris picked up over 20 female hitchhikers. They didn't attack these girls in any way because they were practicing their ruses, the ways to lure the girls into their van voluntarily and without drawing attention. By doing this, they could learn what did and didn't work. In late April, the pair discovered a secluded road in the San Gabriel Mountains, a mountain range located in northern Los Angeles County and western San Bernardino County, California. The road was a fire road and so was gated and locked. Bittica broke the lock with a crowbar and attached his own lock in its place. Now, we're going to take a quick break here to play a trailer for you. It's a podcast I think you'll really, really enjoy. Ye Old Crime. Give them a listen and leave them a review. It really does make all the difference in the world.
I'm Lindsay Valenti.
And I'm Madison Stengel.
And we're the hosts of Ye Old Crime, where we discuss the funny,
hey man, he's a nice guy. And they're like, no, he's disgusting. He has hooves.
Strange. There are EVPs of spirits saying, get out, in a room where patients committed suicide, and obscure crimes of yesteryear.
Here, Justin, here's your first phallic amulet.
Join us Wednesdays, wherever you listen to podcasts, and we'll see you next time with another tale
as old as crime.
There's a lot of information about these crimes out there because of accounts written by Bittica. In one of his entries, he states that he and Norris installed a bed in the rear of the van, and under it they put tools, clothes, and a cooler filled with beer and soft drinks. Their first victim was 16-year-old Lucinda Lynn Schaefer. On the 24th of June 1979, Schaefer was last seen leaving St. Andrew's Presbyterian Church in Torrance, where she had attended a youth meeting. She had been walking back to her grandmother's house at around 7:46 p.m. when Norris noticed her and pointed her out to Bittica, saying, "There's a cute little blonde." They tried to entice Schaefer into their van by offering her a lift and marijuana, but she declined their offers and continued walking. Bittica and Norris drove further ahead of where Lucinda Schaefer had been walking and parked up. Norris got out of the van, opened the passenger side sliding door, and leaned in, meaning his head and shoulders were obscured from view. As Schaefer passed the van, Norris briefly chatted to her before dragging her into the van and closing the door. To muffle the teen's screams, Bittica turned the radio to full volume. Norris bound Lucinda's arms and legs and gagged her with duct tape. The van then sped towards the San Gabriel Mountains. Realizing her screams weren't being heard, Schaefer regained her composure. About her, Bittica wrote that she, quote, displayed a magnificent state of self-control and composed acceptance of the conditions of which she had no control. She shed no tears, offered no resistance, and expressed no great concern for her safety. I guess she knew what was coming. This is going to get graphic now, so I'm going to reiterate my earlier trigger warning and advise you to please exercise discretion. With that said, the two men drove Lucinda Schaefer to the fire road in the San Gabriel Mountains. When they arrived, it was Norris who first raped the teen, having instructed Bittica to take a walk and return in 1 hour. Upon his return, Bittica then raped Schaefer in Norris's absence. Norris then sexually assaulted the girl again. It was during this attack that Schaefer asked him whether they intended to kill her. Norris told her no. Schaefer's one request was to be allowed time to pray before she was killed. It's unclear exactly what happened next, as Bittica and Norris gave differing accounts, but it's said that there was an argument about what to do with Schaefer. Both men later said that during the argument, it was the other who said they should kill her. Schaefer begged for a second to pray before Norris tried to manually strangle her, but the look in her eyes freaked him out, and he ran out of the van to throw up. Bittica then manually strangled Schaefer until she collapsed and began convulsing. During the attack on Schaefer, Bittica dropped his cigarette, which burned a hole in his shirt and scarred his chest. He grabbed a wire coat hanger, twisting it around the girl's neck with some pliers until her convulsions stopped. Schaefer was never afforded the time to pray before her death. The pair then wrapped Lucinda Schaefer's body in a plastic shower curtain and threw her over a steep canyon Bittica had selected. Lucinda Lynn Schaefer's body has never been found. On the 8th of July 1979, just 2 weeks after Schaefer's murder, Bittica and Norris saw 18-year-old Andrea Joy Hall hitchhiking along the Pacific Coast Highway. Hall grew up in Akron, Ohio, and moved to Los Angeles, California in February 1978. At the time of her disappearance, she didn't have a job but earned some money by donating blood. At the time Bittica and Norris saw Andrea Hall, she was hitchhiking to visit her boyfriend in Wilmington. As she walked along the highway, the men began to pull their van over when another vehicle pulled over and offered her a lift, which she accepted. I wish that this was the turning point in Andrea's story, that she ended up being rescued by some weird twist of fate or luck. But rather than moving on, Bittica and Norris began following the vehicle that had picked up Andrea until she got out at Redondo Beach. Norris hid to try and trick Hall into thinking that Bittica was alone. Bittica offered Hall a cold drink from the cooler in the back of the van, and as she went to get the drink, Norris tried to force Andrea into the vehicle. She fought back, but had to give up when Norris began twisting her arm behind her back, hurting her. She was then bound and gagged by Norris. The pair took the 18-year-old to the San Gabriel Mountains, just as they had done with Schaefer. She was raped, as Schaefer had been, twice by Bittica and once by Norris. During Bittica's second attack, he panicked because he thought he saw headlights approaching them. He held his hand over Hall's mouth so she couldn't make a sound, and he dragged her into the bushes. Norris set off in the van, searching for the elusive vehicle. When he returned, they took the poor teen further into the mountains. Bittica then made Andrea walk uphill naked, where he forced her to perform oral sex on him. He also took Polaroid pictures of her. But the torment didn't end there. The men then drove Hall to a third location, where Bittica again walked her up a hill. He had instructed Norris to drive to a nearby store to purchase alcohol, leaving him and the terrified teen alone. He took more Polaroid pictures, exploiting his victim's fear. He took the photos of her terrified face as she begged for her life. Having later seen the Polaroids, Norris described Andrea's face in the photos as being of sheer terror. As some sort of sick challenge, Bittica told Hall he planned to kill her, but still he told her she should come up with as many reasons as she could as to why she should be allowed to live. He's dangling hope in front of her face, knowing full well that regardless of whatever reasons she came up with, she was never going to change his mind, and he was always going to kill her. As she scrambled for reasons, Bittica thrust an ice pick through her ear, before doing the same to the other ear. He then strangled her and threw her body off a cliff. Andrea Joy Hall's body has never been found. On the 3rd of September 1979, the murderous pair saw their next two victims, Jackie Doris Gilliam and Jacqueline Leah Lamp. These would also be their youngest victims at just 15 and 13 years old respectively. The girls had been hitchhiking along the Pacific Coast Highway before resting at a bus stop near Hermosa Beach. It was here that Bittica and Norris spotted them. The men offered the girls a ride, which they accepted. Norris offered them marijuana, which they also accepted. The girls began to panic when they saw Bittica had steered the van off the highway, heading towards the San Gabriel Mountains. When they asked what was going on, Bittica and Norris tried to palm them off with excuses, but the girls were growing increasingly alarmed. Out of desperation, 13-year-old Jacqueline Lamp tried to open the sliding door of the van, so Norris hit her on the back of the head with a bag filled with lead weights. She fell to the floor unconscious. Norris then turned his attention to 15-year-old Gilliam. As he bound and gagged Jackie Gilliam, Lamp regained consciousness. She again attempted to escape. Norris grabbed her, twisting her arm behind her back and dragging her back into the van. As the situation got more and more out of hand, the men worried that witnesses might see them, so Bittica stopped the van, and as Norris wrestled with Lamp, he punched Gilliam in the face. The two men then bound and gagged both girls. The men continued to drive the van to the San Gabriel Mountains, where they held the girls for 2 days. During these 2 days, Lamp and Gilliam were repeatedly, sexually and physically abused by Norris and Bittica. During the nights, one of the men would sleep whilst the other acted as a lookout, and then they would swap. As we've seen before with other victims, Bittica took Lamp up a hill and forced her to pose for pornographic pictures. Bittica seemed obsessed with the idea of photographing his victims. He even asked Norris to take photos of himself and Gilliam, both clothed and nude. Bittica raped Gilliam 3 times. During the first instance, he tape recorded the attack. During the assault, Bittica reportedly forced Gilliam to pretend she was his cousin. He told the young teen that she should feel free to express her pain. The recording has never been found, but it was supposedly buried in a cemetery. The depravity shown by these men seems to be exacerbated with each victim. This next part is particularly brutal, so if you'd like to skip ahead a bit, I honestly don't blame you. Bittica tortured Gilliam in a way I can't begin to imagine. He stabbed her breasts with an ice pick, and he used pliers to tear off part of her nipple. After 2 days of repeated violence and sexual assaults, Lamp and Gilliam were murdered. Norris would later claim to have suggested that Gilliam be killed quickly, as she had been quite cooperative with her attackers, but Bittica said, quote, "No, they only die once anyway." Gilliam was struck in the ears with an ice pick and was then strangled to death. Lamp was then forced out of the van. Bittica shouted at her, quote, "You wanted to stay a virgin, now you can die a virgin." Norris then struck her round the head with a sledgehammer. Bittica then strangled her until he was sure she was dead. The men were therefore horrified when the girl's eyes opened. Norris again hit the young girl over the head, and Bittica again strangled her. The girls' bodies were thrown over an embankment. During Halloween of 1979, Bittica and Norris abducted 16-year-old Shirley Lynette Ledford. Ledford had been hitchhiking home from a Halloween party when she unfortunately accepted a ride home from Bittica and Norris. Ledford felt comfortable accepting a lift from the pair because she actually recognised Bittica, who had regularly attended the restaurant where she held a part-time job. Once she was in the van, Norris offered Ledford marijuana, which she declined. Bittica drove the van, whilst Norris produced a knife. He then bound and gagged Ledford with construction tape. Bittica and Norris swapped places, and Norris drove around for about an hour, whilst Bittica got in the back of the van with Ledford. He began by removing the tape, tormenting the 16-year-old by slapping her and mocking her. It escalated as he began punching her, repeatedly shouting for her to say something. As Ledford began screaming, he ordered for her to scream louder. She continued to scream, hoping somebody, anybody, would hear her. Bittica continued to hit her, asking, "What's the matter? Don't you like to scream?" As the poor girl began to cry, she pleaded with Bittica, asking him not to touch her. This seemed to make Bittica mad. He ordered her to scream as loud as she wanted. Then he struck her with a hammer. He then hit her breasts with his fists before torturing her with pliers. During this assault, he raped and sodomized Ledford. She tried to plead for him to stop, as Bittica is heard rooting around in the toolbox for the pliers or the sledgehammer. That's right, Bittica recorded his attack on Ledford. He had switched the tape recorder on as he got into the back of the van. Norris would later recall just hearing screaming, constant screaming from the back of the van. This recording was recovered, and having briefly read the transcript when I was researching this case, it might be one of the most traumatic and scarring recordings ever made. Norris eventually switched places with Bittica, switching on the tape recorder again. Norris shouted at Ledford, telling her to scream or he would make her scream. In response, Ledford said she would scream, but only if he stopped hitting her. She then let out several high-pitched shrieks. Norris struck Ledford with the sledgehammer, breaking her elbow. She pleaded with him, "Don't hit me again." Norris ignored her pleas for mercy and went on to strike her 25 times upon the same elbow he had already broken. When she continued to scream and cry, he asked her, "What are you snivelling about?" 2 hours after she got into the van, Norris killed Ledford by strangling her with a wire coat hanger, which he tightened with pliers. Ledford did not react when she was being strangled, maybe because she knew the pain was going to stop soon. In a very bold and unexpected move, the men agreed to discard Ledford's body on someone's front lawn in order to draw attention from the press. They found a house in Sunland and left Ledford's body in a bed of ivy in the front garden. The body of Shirley Lynette Ledford was found by a jogger the next morning. Here's a quote from forensic psychiatrist Dr. Ronald Markman, who said, when reciting the conclusions of his analysis of Bittica and Norris in 1989, quote, "They lack the internal prohibitions or conscience that keep most of us from giving full expression to our most primitive and sometimes violent impulses." We're now going to look at the investigation into the murders and the culprits. It all started with a friend of Norris's, Joseph Jackson. The two men had been incarcerated together at the California Men's Colony. Norris became reacquainted with Joseph Jackson in November 1979 and decided to confide in his old friend. Why? I have absolutely no idea. But anyway, he told Jackson intimate and graphic details of the murder of Shirley Lynette Ledford, details only the killer would know. It should be noted that by this point, hers was the only body that had been found. Norris told Jackson that there had been 5 murders, but that there had also been 3 additional abductions and attempted abductions where the victims had either escaped or, as in one instance, they had been raped and then released. After his conversation with Norris, Jackson went to his attorney regarding what he had been told. His attorney advised him to speak to the authorities, to tell them all he had been told. Jackson agreed, and he and his attorney contacted the LA Police Department, who then handed the case to the Hermosa Beach Police. The case ended up on the desk of Hermosa Beach Detective Paul Bynum, who was tasked with investigating Joseph Jackson's claims. During a preliminary look, the accounts that Jackson gave did appear to match earlier reports on file of several teenage girls who had been reported missing over the past 5 months. One incident that Jackson recalled also matched a report from the 30th of September, where a woman had been sprayed with mace and then dragged into a van. She was subsequently raped by both men. The victim in this case, Robin Robeck, had described the men as Caucasian and in their mid-30s. Police had not yet found her attackers. Detective Bynum sent an investigator to Robeck's house in Oregon, where she positively identified Bittica and Norris's mugshots out of a group, confirming that these were the men who had abducted and raped her. Hermosa Beach Police decided to place Roy Norris under surveillance, and within a few days, They saw him dealing marijuana, and so, on the 20th of November 1979, he was arrested for a parole violation. That same day, Lawrence Bittica was also arrested at a Burbank motel where he was living for the rape of Robin Robeck. But when it came to a police lineup, Robeck was not able to positively identify her attackers. Despite this, both men were held for parole violations resulting from drug-related offences. As police searched Bittica's apartment, they found some Polaroids of Jackie Gilliam and Andrea Hall. Both were reported as missing. Inside Bittica and Norris's van, Murder Mac, investigators found some very, very sinister items. A sledgehammer, a bag filled with lead weights, a book detailing how to locate police radio frequencies, a jar of Vaseline, 2 necklaces, and a tape recording of a woman in distress, screaming and pleading for mercy. I hate to have to say this, but it was Shirley Lynette Ledford's own mother who identified her only daughter's voice from the tape. Her mother had to listen to her daughter screaming, begging and pleading whilst she was being physically and sexually assaulted. The other voices in the tape were identified as Roy Norris and Lawrence Bittica. Something quite strange found in Bittica's motel were several bottles of acidic materials. It was later discovered that Bittica had intended to use the acid on their next victim. Fortunately, they were stopped before they could hurt anyone else. In Norris's apartment, police found a bracelet that he'd taken from Ledford as a souvenir. Police found almost 500 Polaroid pictures of women and girls taken at Redondo Beach and Hermosa Beach. Some also taken at a Burbank high school. Most of the females featured in the photographs were completely unaware that their photos had been taken. On the 30th of November 1979, Norris appeared in court for a preliminary hearing in relation to the rape of Robin Robeck. Norris waived his Miranda rights, and then the questions started. Detective Bynum and Deputy District Attorney Stephen Kay questioned Norris about the rape of Robin Robeck, about the statements Joseph Jackson made to police, and about the evidence recovered from his home and Bittica's. He initially tried to deny any involvement, but as the evidence began to stack up against him, Norris started to confess. In what was described as a casual, unconcerned manner, Norris explained to the court that he and Bittica had been driving along the Pacific Coast Highway, trying to entice attractive girls into their van by promising them a lift or marijuana. He said that 4 girls had accepted lifts, but that one of their victims had been abducted by force. Norris recalled how the girls were overpowered, gagged, and driven into the San Gabriel Mountains. From photos, this mountainous area looks so beautiful and yet really, really isolated. So you can imagine that when the men were up there, they could attack their victims without worrying that they would be found. The men would begin by sexually assaulting the girls. Then they were usually killed by strangulation, although 2 had been attacked with ice picks before being strangled. In court, Norris admitted his role in some of the attacks. He admitted that he had indeed hit 13-year-old Jacqueline Lamp around the head with a sledgehammer as Bittica strangled her. He also admitted to hitting Shirley Ledford on the elbow with a sledgehammer before strangling her to death. Norris told the court that the level of brutality exhibited by Bittica towards their victims seemed to increase with each victim they managed to convince to get into their van. The evidence supported Norris's claims. On the 7th of February 1980, a statement was issued by police. The LA County Sheriff, Peter Pitchess, said that the victims had been subjected to, quote, sadistic and barbaric abuse. He told the press that 5 charges of first-degree murder would be sought against Bittica and Norris. Having carefully analysed the Polaroid pictures, police had identified and located 60 of the young women depicted. Thankfully, they hadn't been harmed. Police also identified 19 women who had been reported missing. There's a chance that these were victims of Bittica and Norris, but, as explained by Pitchess, there was no conclusive evidence to confirm whether they were victims of the Toolbox Killers. What this means is that there were potentially more victims, but we'll unfortunately never know for sure. In the hope of finding all the victims' bodies so they could be returned to their families and laid to rest, police took Roy Norris back to where it all happened, to the San Gabriel Mountains. Norris took police to the area where he believed Schaefer and Hall's bodies would be. But unfortunately, despite extensive searches by police, their bodies were not found and have not been found in the years since. On the 9th of February 1980, the skeletonized bodies of Lamp and Gilliam were found at the bottom of a canyon. What's so heartbreaking is that the skeletons revealed the true extent of the injuries the young girls sustained at the hands of Bittica and Norris. There were numerous indentations in their bones from a hammer and an ice pick. In February 1980, Lawrence Bittica and Roy Norris were formally charged with the murders of 5 girls. Unsurprisingly, Bittica was denied bail, but what did shock me was that Norris's bail was set at $10,000. Within a month of being formally charged, Norris had accepted a plea bargain, which required him to testify against his co-defendant, Lawrence Bittica, in return for the prosecution agreeing they would not seek the death penalty in Norris's case. They would also not seek a sentence of life without the possibility of parole. Norris pleaded guilty on the 18th of March 1980, following his arraignment. He pleaded to 4 counts of first-degree murder, 1 count of second-degree murder in relation to the death of Andrea Hall, 2 counts of rape, and 1 count of robbery. His sentencing was postponed until the 7th of May 1980. Prior to his sentencing, as is common practice, Norris met with a probation officer who would testify at his sentencing. Following the probation officer's meeting with Norris, the officer noted that he, quote, never exhibited any remorse or compassion about his brutal acts towards the victims. The defendant appears compulsive in his need to inflict pain and torture upon women. During this meeting, Norris continued to accuse Bittica of the torture inflicted upon their victims. He himself admitted that he found pleasure in the feeling of dominance he held over the girls, which was why he continued to be involved. The probation officer concluded that Norris, quote, can realistically be regarded as an extreme sociopath whose depraved pattern of behaviour is beyond rehabilitation. On the 7th of May, Norris was sentenced to 45 years to life imprisonment, meaning he would be eligible for parole in 2010. So that just leaves Lawrence Bittica. Bittica had been arraigned on the 24th of April 1980. This is when you have the charges formally put to you in court. Bittica was facing 29 charges of criminal conspiracy and possession of a firearm. He was also charged with 2 counts of conspiracy to commit murder, dating from December 1970, when he had tried to convince 2 inmates who were due to be released to go and kill Robin Robeck, the rape victim who was due to testify against him in an upcoming court hearing. Unfortunately, the charge of rape stemming from the attack on Robin Robeck would be dropped because of a lack of physical evidence, as well as her difficulty in identifying Norris and Bittica as her attackers in the police lineup. In court, Bittica refused to enter his pleas, choosing to remain silent. The judge therefore entered pleas of not guilty for him. The trial of Lawrence Bittica began on the 19th of January 1981. He was tried in Torrance before His Honour Judge Thomas Fredericks. As we know, the prosecution's star witness was Louis Norris, whose testimony began on the 22nd of January. Norris explained in court how he became acquainted with Bittica and how the pair came up with their monstrous plan to kidnap, rape, and kill teenage girls. Norris stated that it was after he told Bittica about an unsuccessful attempted abduction that the pair agreed to act together when abducting their future victims. Norris recounted the Toolbox Killers' horrific acts chronologically for the court, including intimate details of the murders, the rape of Robin Robeck, the attempted abduction of a woman called Jan Malin, and the attempted abduction of another unidentified woman. 20-year-old Jan Malin was parking her car in an apartment garage when Bittica approached her and sprayed her with mace before attempting to drag her into the van. Malin screamed, drawing attention. Norris drove away without Bittica, who fled on foot. Malin's testimony in court would corroborate with Norris's account. In relation to the murder of Lucinda Lynn Schaefer, Norris explained to the court that he was unsuccessful in his attempt to strangle the girl, which was when Bittica took over and strangled her with a wire coat hanger. When talking about the murder of Andrea Hall, Norris recalled how Bittica had instructed him to drive to a nearby store to purchase alcohol. Upon his return, he found a smiling Bittica clutching Polaroids he had taken of Hall after telling her he was going to kill her. Regarding Jacqueline Leah Lamp and Jackie Doris Gilliam, Norris told the court that the girls were kept captive for some time before they were murdered, over a day. He revealed to the court that Bittica had killed Gilliam before he, Norris, hit Lamp about the head. Bittica then strangled her. When talking about the final victim, Shirley Lynette Ledford, Norris said that Bittica had insisted he, Norris, commit the murder as he hadn't killed anyone yet. Norris said he expected this, and so agreed. Before the court, Norris admitted that he had killed Ledford by strangling her with a coat hanger, which he tightened with pliers. It should be noted that although the bodies of Lucinda Schaefer and Andrea Hall were never found, the defense did not dispute that they were both dead. The prosecution had other witnesses, aside from Norris, who testified against Bittica in court. One witness, a neighbour of Bittica's, Christina Drayle, who was 17, testified that Bittica had shown her a Polaroid of the victim, Jackie Gilliam, whilst stating, quote, "The girls I get won't talk anymore." She also testified that Bittica had played her a recording of the rape of Gilliam. Another witness, Lloyd Douglas, had shared a jail cell with Lawrence Bittica following his arrest in November 1979. Douglas told the court that Bittica had discussed his crimes, specifically his attacks on Gilliam and Ledford. Douglas went into frighteningly intimate detail to prove that Bittica had indeed divulged his secrets to him. Another cellmate of Bittica's, David Lambert, recalled how Bittica asked him to draw a picture of a girl on the wall of their cell. Oh, this is so creepy. Bittica remarked that it looked like Cindy. He then asked Lambert to add a coat hanger and pliers. Bittica then signed the picture with Pliers Bittica, the jail nickname he had acquired. It was reported that Bittica had actually signed autographs in prison using this nickname. With one of the autographs, he wrote, "Hitchhikers welcome, females especially." In another, he wrote, "Norris did it." Richard Dreiber, another resident at the motel where Bittica had stayed, testified in return for dismissal of a charge of possession of an explosive. He told the court that Bittica had showed him nude photographs of the victims, told him that one was named Cindy and that she had been killed. When shown a picture of Lucinda Schaefer, Dreiber confirmed she was one of the girls in the photographs he had seen. He went on to tell the court that Bittica had confessed to kidnapping and killing 2 girls on one occasion, but incorrectly identified Schaefer as one of the 2. He did, however, correctly identify a photo of Gilliam. Another resident, Mike Horn, testified that the defendant showed him photographs of Gilliam and Hall. When it was the defence's turn to speak, they attempted to argue that Louis Norris was the real criminal mastermind and that Bittica only became aware of his partner's actions shortly before his arrest. The defense told the court that Norris had admitted to Bittica that he had murdered numerous girls with whom he had had sexual encounters. The defense produced a witness of their own, Richard Shupman, who testified that Norris had a deep desire to rape young girls and that he found sexual stimulation from the look of shock and fear on their faces. The defense tried to argue that the Polaroids were actually taken by Norris, who wanted to capture that same look of shock and fear in a photograph so he could keep it forever. The audio tape of the pair's torture and murder of Shirley Lynette Ledford was the prosecution's most damning piece of evidence. Norris testified that Bittica repeatedly played the tape, finding the contents funny. When recalling the contents of the tape in April 1997, many years after the trial, Norris said the following, quote, "We've all heard women scream in horror films. Still, we know that no one is really screaming. Why? Simply because an actress can't produce some sounds that convince us that something vile and heinous is happening. If you ever heard that tape, there is just no possible way that you'd not begin crying and trembling. I doubt you could listen to more than a full 60 seconds of it." The prosecutor, Stephen Kay, had to warn the jury, "For those of you who do not know what hell is like, you will find out." There were over 100 people in the courtroom as the tape was played. Its contents caused an array of responses from the people hearing it for the first time. Many cried, some buried their heads in their hands, and some had to get out of there, leaving the courtroom in a hurry. Even the prosecutor struggled. Getting tearful, he said, quote, "Everybody who has heard that tape has had it affect their lives. I just picture those girls, how alone they were when they died." When asked about whether the tape should have been played and the emotional trauma it could cause for those who heard it, Prosecutor Kay replied, "You're darn right it should have been. The jury needs to know what these guys did." It was reported that Bittica remained undisturbed, smiling as the recording played.
Did you at any time ever use an ice pick?
No, sir.
You struck Miss Lamp with a sledgehammer. Do you recall the sledgehammer which was introduced?
Yes, sir, I recall it.
Was that true?
No, sir.
Lawrence Bittica, with an IQ of 138, dragged high school girls into his van, then murdered them by twisting a coat hanger around their throat with a pair of pliers. When his tape recording of one murder was played in court, people rushed outside and vomited.
I touched Miss Ledford on the breast with the cold metal pliers, and if you listen to the tape, you'll hear those pliers being replaced in the toolbox a few seconds later.
Oh, what did you touch her on the breast for with a pair of pliers?
To shock her with the cold metal.
On the 5th of February 1981, Lawrence Bittica testified in his own defense. Bittica denied any knowledge of the abduction and murder of Lucinda Lynn Schaefer. He said that Norris told him that Norris and another man had committed the crimes against Ledford. With regards to Andrea Hall, he told the court that he had paid for her to pose for Polaroids, after which Hall had agreed to have sex with him for $200. He said that Norris then walked Hall into the San Gabriel Mountains before returning alone. Bittica claimed that Norris had told Hall to find her own way home. Similarly, Bittica claimed that he last saw Jackie Gilliam and Jacqueline Lamp alone with Norris in the van. Bittica told the court that he had paid Gilliam to pose for pictures and for sex, but that was it. Bittica said that the next day, Norris dropped him off at Norris's residence and left to drive the girls home in the van. Bittica testified he never saw the girls again. It should be noted that Bittica took additional nude photographs of Gilliam. Some of these came into the possession of Bittica's defense counsel, who turned them over to the police, and they were admitted into evidence. When talking about the murder of Shirley Lynette Ledford, Bittica told the court that Ledford was putting the scream on and would do so on cue for the tape recorder. He explained that she had not been tortured in his presence. Once again, he said that the victim, in this case Ledford, had last been alone with Norris when he, Bittica, returned to his motel, having made the tape. Bittica accepted his involvement with the attack on Jan Malin. However, he argued that they were not trying to kidnap her, but rather wanted to test the effectiveness of mace. Yeah, sure. Under cross-examination, Bittica acknowledged that he had begun writing a book and had shown drafts to a newspaper and a guard. He called the book The Last Ride. In it, he wrote a detailed account of the murder of Lucinda Schaefer. It also described the abduction and rape of Andrea Hall, but did not discuss her murder, and the attacks of Gillian and Lamp. Bittica said that the book was part fact, based on what Bittica had been told by Norris, and part fiction. Altogether, the trial lasted over 3 weeks. Closing arguments began on the 9th of February 1981. These are really, really important closing arguments because they are one of the last things that the jury hears before they go and deliberate. They therefore have to be constructed very carefully. Prosecutor Stephen Kay took an emotive stance. He apologized to the jury that he was only asking for the death penalty, adding that he wished the same suffering that Bittica inflicted could be inflicted on him as punishment. Kay told the jury that Bittica was a poor excuse for a man as he held the photos of the 5 victims in his hand, showing them to the jury as he spoke. Kay called this case one of the most shocking and brutal cases in American criminal history. Then he asked the jury, quote, "If the death penalty is not appropriate in this case, then when will it ever be?" Then it was defense attorney Albert Garber's turn to speak to the jury. He requested that they discount the testimony of Norris, reiterating that it was indeed Norris who committed the murders and not his client. He described the prosecutor's testimony as bloodlust, adding that the prosecution had simply repeated the gory details of the murders. Garber reminded the jury of what psychologist Michael Maloney had said. He had testified that Bittica did not suffer with any mental illness, but was unable to empathize with the feelings and emotions of others. He classified Bittica as an antisocial personality. Maloney testified that Bittica's previous convictions, of which there were many, were for non-violent offences, except the 1974 stabbing of Gary Louis, meaning these current charges were completely out of character for him, and were more likely committed by Norris, who had a history of attacking women. The defence concluded their closing argument by stating that there was insufficient corroborative evidence to convict Bittica. After 3 days of deliberating, on the 17th of February 1981, the jury had reached their verdict. They found Lawrence Bittica guilty of 5 counts of first-degree murder, 1 charge of conspiracy to commit first-degree murder, 5 charges of kidnapping, 9 charges of rape, 2 charges of forcible oral copulation, 1 charge of sodomy, and 3 charges of unlawful possession of a firearm. 2 days later, on the 19th, deliberations began as to how Bittica should be punished: life without parole or death. The trial court instructed the penalty jury in the language of the 1978 death penalty law. the prosecutor's argument placed the greatest emphasis on the appropriateness of the death penalty in this case. Shortly after his argument, he asked the jury, quote, "What penalty has Lawrence Sigmund Bittica earned in this case? Has he earned the death penalty for the torture and suffering that he inflicted on Cindy Schaefer, Andrea Hall, Jackie Gilliam, Leah Lamp, and Lynette Ledford? Has he earned the death penalty for the barbaric and callous nature of his crimes, which has shocked the public conscience and greatly affected all of us? Or has he earned the lesser penalty of life imprisonment without the possibility of parole, and a chance to spread his tales of torture and violence and bloodshed to other adoring prisoners, such as the Richard Shupman type, who will someday be paroled to prey on the young girls in our society? Does anyone actually believe that life imprisonment without possibility of parole is punishment for Mr. Bittica? Where do you think he's been for 18 of the last 22 years? Prison, of course. It's his home." End quote. After describing the defendant's life in prison, the prosecutor continued, quote, "Make no mistake about it, ladies and gentlemen. A sentence of life imprisonment without possibility of parole for Lawrence Bittica in this case would be a total, complete victory for him. When should the death penalty be imposed? Some cases are so brutal, so vicious, so horrendous, so inhumane, that in order for us to exist as a society, we have to totally repudiate the conduct involved, and we have to say, we will not accept it, we will not allow it, and the one mainly responsible for it has to suffer the supreme penalty. If the death penalty isn't proper in this case, when would it ever be proper?" End quote. Finally, after reviewing the evidence in the case and discussing the statutory factors, the prosecutor concluded, quote, "What has this monster earned? The death penalty or life imprisonment without possibility of parole? My only regret in this case, ladies and gentlemen, is that I can't ask you for more than the death penalty. Because even if Bittica is executed in the gas chamber at San Quentin, that's quick and humane compared to what he did to these poor, tortured girls." End quote. Other portions of the prosecutor's argument, however, do not correctly state the law. The prosecutor told the jury, quote, "Now here's the real important paragraph. If you conclude that the aggravating circumstances outweigh the mitigating circumstance, you shall impose a sentence of death. Now, that takes some of the burden off of you. It's not a question of whether you like the death penalty, or you don't like it, or you're in favor of it, or you're opposed to it. You're bound by law. You're bound as jurors to follow the law. What this means is, say to give a simple example, if we were to give actual weight in pounds and ounces to the aggravating circumstances and the mitigating circumstances, if the aggravating circumstances weighed 10 pounds and 1 ounce, and the mitigating circumstances weighed 10 pounds, then you would be duty-bound to impose a death penalty. Now, obviously, I don't think in this case that it's even close. I mean, the aggravating circumstance on a scale, they're going to put the scale way down at the bottom, and the mitigating circumstances aren't going to make that scale even come off the ground. If you were to give a percentage to it, if you said 50.1% of the evidence pointed to aggravating circumstances and 49.9% pointed to mitigating circumstances, then you'd still have to impose a sentence of death. But again, I really don't think that it's going to be that close in this case." End quote. The jury deliberated for just 90 minutes before they delivered their sentence. Death for the 5 counts of first-degree murder. As the verdict was delivered, Bittica showed no outward emotion. The judge then ordered that Bittica appear before the court on the 24th of March for formal sentencing. It was on that date that Lawrence Bittica was formally sentenced to death. In the event that the sentence was ever reverted to life imprisonment, Judge Thomas Fredericks imposed an alternative sentence of 199 years, 4 months imprisonment to take effect immediately. Lawrence Bittica wanted to appeal pretty much everything that happened in his trial. To start, there was his complaint about Maureen Mclaughlin. Mclaughlin was a psychologist brought in by Bittica's defense counsel, and it was her job to advise regarding jury selection. Her fee was $500 a day. I wish I earned that much. During the first day of jury selection, jurors were questioned concerning their views of the death penalty. Mclaughlin was present to assist Bittica's defense counsel. At the start of the second day, the court called Bittica's counsel and Mclaughlin into chambers where they said that Mclaughlin's work was not going to be authorized. The judge explained that he would authorize payment for her work the first day, but that was it. Defense counsel raised no objections and instead apologized for not notifying the court about his arrangement with Mclaughlin. Bittica raised concerns regarding the jury. One juror, Sina Gage, stated, "Before I ever came here, I felt in my head he was already guilty." This was because of newspaper articles published about the case. The Supreme Court of California ruled that under the law, no person shall be disqualified as a juror by reason of having formed or expressed an opinion upon the matter based on rumor, public journals, newspapers, or other literature, if it appears to the court that he or she can and will act impartially and fairly upon the matters to be submitted to him or her. While Gage at one point agreed she could not fairly judge and evaluate this case, she later said she could decide it strictly on the evidence in court. The Supreme Court ruled that the trial court did not act improperly in denying the challenge for cause. The second juror, Cheryl Staggs, had heard something about the case on TV and in the newspaper. Staggs told the judge she had worked at a rape crisis center and did not believe she could be impartial in such a case. The Supreme Court held that the trial court did make a mistake by denying the challenge for cause. Juror Hine formed an opinion of the case based on newspaper reports. When asked whether he could put that opinion out of his mind and decide the case on the basis of the evidence, he replied, quote, "I wish I could say yes, okay, but I really don't think so." Hine said he would try to be impartial, but that he would have a difficult time because he already had preconceived notions. The Supreme Court said that the trial court should have sustained the challenge for cause. Juror Lynn told the court that although she had not been influenced by the media, she didn't think she could be fair because she would get too emotionally involved. She believed this was because she had a daughter around the age of the victims. Kuricki stated that she felt she could follow the court's instructions and could base her decisions solely on the evidence. She also stated that she believed a person is innocent until proven guilty. The Supreme Court held that the trial court acted properly in denying the challenge for cause. The final juror Bittica complained about was Marguerite Perazzo, who, when asked whether she would automatically vote in favor of death, answered in an equivocal way. The Supreme Court held that the judge did not err in finding her answer insufficient to require her dismissal for cause. The Supreme Court reported that the defendant Bittica raised 40 complaints about the guilt phase of his trial. The court immediately disregarded a number of the complaints simply because they were either just not of arguable merit or because they had already been dealt with. As we know, Louis Norris and the prosecution entered a plea deal, which meant that in return for testifying against Bittica, Norris would not face the death penalty or life imprisonment without the possibility of parole. Norris also agreed, as part of the deal, to help the sheriff find the bodies and any physical evidence and to plead guilty to 5 counts of murder, 2 counts of rape, and 1 of robbery. Bittica tried to argue that the agreement between the prosecution and Norris didn't meet the necessary criteria. Specifically, Bittica argued that Norris did not comply with the sections where he was required to give a complete and truthful account of both his and Larry Bittica's participation in the murders, and to give complete and truthful testimony at all court proceedings, including preliminary hearings and trials, wherein Larry Bittica and others are defendants. Bittica stated that these provisions required Norris to testify that he, Bittica, participated in the murders, even if that testimony were untrue. The Supreme Court held that Bittica's interpretation was not reasonable, as Norris was also required to testify truthfully under the agreement. Bittica's next complaint was about the tape of Ledford's attack. 8 months before the trial, the defence were given the opportunity to listen to the recording. The defence then asked permission from the prosecution to make a better copy. However, the prosecution objected. They didn't want the defence taking the original tape from the court. The court itself refused to permit any copying of the tape. When the defence tried to raise the issue during the trial, the court criticised them, saying that their motion was untimely. Quote, "The time for obtaining copies of evidence and submitting them to expert examination is before trial, not during the prosecution's case." Another issue Bittica raised was regarding the testimony concerning Bittica's attempt to abduct Jan Malin. Bittica argued that this testimony should not have been allowed because he was not actually charged with any crime against Malin. To be clear, Bittica was charged with conspiracy to kidnap, and the incident with Jan Malin was listed as an overt act in support of the charged conspiracy. Evidence regarding the Malin attack was excluded at the preliminary examination, but defence counsel didn't move to dismiss the accompanying overt act allegation. It was therefore held that the trial court did not err in admitting the evidence. So let's go back to Bittica's book, The Last Ride, which might just be the most sinister name for a book I've ever heard, considering Bittica's crimes. He described the book, Bittica described the book as part fact and part fiction. He supposedly showed the book to a newspaper reporter who divulged its contents in an article. According to Bittica, Sergeant Budds asked him about his book, to which Bittica asked if he'd like to read and correct it. Budds initially declined, but a few days later he asked if he could read it. Bittica said he would allow Budds to read it, but only for the purpose of correcting it. It was not to be disclosed to anyone or used by anyone for any purpose. The prosecution did not introduce the book in its case in chief, but made use of it when cross-examining Bittica. The trial court denied Bittica's objection as untimely. Bittica maintained his objection was based on a violation of his Fifth and Sixth Amendment rights, because he said Sergeant Budds didn't read him his Miranda rights and Bittica's defence counsel were not present. The court held that since Budds could have seized the manuscript anyway without asking for or receiving consent, the issues Bittica raised were immaterial to the validity of the seizure. Under cross-examination, the prosecutor asked Bittica why he had not objected when Norris left Andrea Hall in the mountains. Bittica explained that he was intimidated by Norris. The prosecutor didn't believe this and asked, "In fact, Mr. Bittica, Mr. Norris was afraid of you. Isn't that true?" Bittica denied this, saying that Norris was trained in martial arts. The prosecutor reminded Bittica that it was he who had almost killed a man with a knife, referring to the 1974 attack on shop employee Gary Louis. The defence objected, but the court overruled their objection. The jury already knew Bittica had been convicted of a felony because they had heard testimony regarding how the pair met in prison. They did not know the nature of the felony. Bittica complained about this assault being brought up by the prosecutor because he argued that the 1974 offence had no similarity to the crimes for which he was being tried. He therefore argued that any evidence regarding the 1974 offence was inadmissible. The prosecutor argued that he offered the evidence to prove Bittica's state of mind, also to prove that he was not one to be easily intimidated by anyone, including Norris. The Supreme Court concluded that the evidence was admissible. Bittica didn't like that during the trial, the court had refused to grant defense counsel permission to tell the jury that Norris had been classified as a mentally disordered sex offender. The prosecution argued that members of the jury would not understand what that term meant and would distract from the trial, as experts would have to be called in to testify about what it meant to be a mentally disordered sex offender. The California Supreme Court held that the trial court's ruling didn't stop the defense from presenting evidence about Norris's sexual proclivities. It only stopped the defense from presenting evidence that proved Norris's classification. The Supreme Court held that since classification was a technical one, which would have to be explained to the jury and would add little to the case overall, the trial court's ruling was the correct one. During the trial, when examining Joe Jackson, defense counsel asked whether he and Norris were involved in an attempted rape in April of 1979. The court sustained the prosecutor's objection. You see, the defense had a right to attempt to show that Norris and Jackson had committed some of the crimes of which Norris was being charged. But evidence that they committed some other crime is inadmissible unless the defense can show there was some relationship between the attempted rape in April and the crimes to which Norris pled guilty. The defense failed to offer any proof, and so the trial court's ruling was correct. Bittica's complaint number 3655, Christina Drayle testified in court that when she rejected Bittica's advances, he pulled a gun and said, "You wouldn't argue if I pulled the trigger." Defense counsel sought to impeach her by having evidence admitted that allegedly proved she had previously made false charges of sexual molestation against two men. The trial court upheld the objection, saying, quote, "The value of the evidence as impeachment depends upon proof that the prior charges were false. This would, in effect, force the parties to present evidence concerning two long-past sexual incidents which never reached the point of any formal charges. Such a proceeding would consume considerable time and divert the attention of the jury from the case at hand." During Bittica's trial, the prosecution offered a lot of evidence which aimed to show the jury Bittica's psychological disposition towards acts of violence and his interest in sexual torture. Such evidence included testimony from Richard Shupman concerning Bittica's sexual fantasies, sadomasochistic and bondage-type magazines found in Bittica's possession, and evidence that the defendant wrote a threatening letter to the judge who presided over Bittica's prior assault trial. This evidence was presented in court with largely no objections from the defense. The Supreme Court held that, quote, "The defendant's failure to object to inadmissible evidence or to request limiting instructions when evidence was admissible for other purposes bars him from raising the issue on appeal." Honestly, if you're wondering whether the list of Bittica's complaints ever ends, I promise it does. Just bear with me. Shupman testified during Bittica's trial that he received a letter from the defendant on or about the 14th of September 1979. Under cross-examination, the prosecutor asked him, "Isn't it a fact, Mr. Shupman, that he wrote you about the rape and killing of a girl in the mountains before September 14th? Shupman denied receiving such a letter, and the prosecutor didn't mention the matter any further. Bittica invoked the rule that it is improper to ask questions which clearly suggest the existence of facts which would have been harmful to the defendant in the absence of a good faith belief by the prosecutor that the questions would be answered in the affirmative, or with a disbelief on his part that the facts could be proved and a purpose to prove them, if their existence should be denied. In Bittica's case, there was evidence that Shupman received letters from the defendant which he destroyed, but there is no evidence as to the contents or what the prosecutor knew of the contents. It also cannot be determined whether the prosecutor, at the time he asked the question, intended to prove the fact at issue. The Supreme Court held that misconduct had not been demonstrated. On cross-examination, and without being too specific regarding their location, Bittica admitted that he had hidden a number of photographs and one tape by burying them at Forest Lawn Cemetery. Despite being found in contempt of court, Bittica still refused to say where they were hidden. The prosecutor asked Bittica 9 times where the photographs were, but each time he refused to reveal their location. In his closing argument, the prosecutor suggested to the jury that the photographs and tapes may have shown scenes of torture or murder. Bittica's defense counsel argued in court that the prosecutor was badgering the defendant, but the prosecution argued that when a defendant admits to concealing evidence and defies a court order to reveal its location, they should have considerable scope to question him. Bittica argued that the prosecutor's closing argument was contrary to evidence, since Norris and others who had seen the photographs said they only described scenes of sexual activity, not torture. The Supreme Court held that the prosecutor could reasonably argue that if the photographs supported Bittica's version of the facts, he wouldn't want to conceal those photos. The trial court instructed the jury that in determining the credibility of a witness, it could consider prior felony convictions. The jury had heard evidence of some felony convictions which, under the law at the time of the trial, would not be admissible to impeach. It had heard about the defendant's prior conviction for assault with a deadly weapon and Shupman's prior conviction for murder. Prosecution witnesses were also tainted, as the jury learned of Norris's prior rape conviction and Lloyd Douglas's convictions for manslaughter and burglary. The case law states that a felony conviction was admissible to impeach only if the offence bore upon accuracy. It was held that only Douglas's conviction for burglary would meet that test. The Supreme Court held, quote, "In light of the overwhelming evidence of the defendant's guilt, we find no reasonable probability that, absent the error in question, the jury would have reached a different result." The trial court instructed the jury that it could find first-degree murder based on the infliction of torture if 2 requirements were met. The first, the acts which cause death must involve a high degree of probability of death, and 2, the defendant must commit an act with a willful, deliberate, and premeditated intent to inflict extreme and prolonged pain. Bittica complained that the instructions were incomplete because they omit the purpose of the torture. In the case of People v. Tubby, murder by torture was defined as requiring an intent to cause cruel suffering, either for the purpose of revenge, extortion, persuasion, or to satisfy some other untoward propensity. In People v. Wiley, they quoted Tubby and required that the defendant commit such an act or acts with the intent to cause cruel pain and suffering for the purpose of revenge, extortion, persuasion, or for any other sadistic purpose. When Bittica's trial was taking place in 1981, the court overlooked the case law and said, quote, "We agree with the defendant that this instruction was erroneously incomplete. It is apparent, however, that the defendant was not prejudiced under any applicable standard of prejudice, for while the defendant disputes how many victims were tortured, it is undisputed that whatever torture was inflicted was done for a sadistic purpose." The jury found 38 special circumstances. Among them were 20 multiple murder special circumstances. One such special circumstance would suffice to determine that the defendant had in this proceeding been convicted of more than one murder. The remaining 19 were superfluous. The jury found at least 14 valid special circumstances, far more than is normally found in most death penalty cases. Bittica challenged 5 of the 38 special circumstance finding. One such objection was to the finding that Lamp was intentionally killed because she was a witness to a crime. He tried to argue that this special circumstance applied only if the killing was not committed during the commission of the crime to which she was a witness. The Supreme Court shot him down on this one, saying that they didn't find it necessary to resolve these issues as a single valid special circumstance is sufficient to determine the defendant is eligible for the death penalty. The court held that there was no reasonable possibility that any error respecting the number of special circumstances affected the result. During the penalty phase, the defense presented testimony from Dr. Maloney, a psychologist who described Bittica's history and personality and concluded that he had an antisocial personality disorder. Dr. Tronkman, a psychiatrist, was also called to give evidence. Dr. Tronkman testified that Bittica may have committed the 1974 assault, again the stabbing of the shop assistant, whilst in an altered state of consciousness. The prosecution called a psychiatrist, Dr. Markman, who testified that Bittica was not mentally ill at the time of the 1974 assault and was not mentally ill at the time of the murders. Bittica attempted to attack the credibility of Dr. Markman's testimony. The Supreme Court held that as it was the defense who opened up the issue of Bittica's mental condition, the prosecution should have the right to present rebuttal evidence on the topic. At the guilt phase of the trial, the jury heard evidence regarding uncharged crimes, specifically the assault and kidnapping of Jan Malin, or attempted kidnapping. The prosecutor referred to this incident in his penalty phase argument. However, the court failed to instruct the jury at the penalty phase that before it could consider these crimes as aggravating factors, they must find beyond a reasonable doubt that the defendant did indeed commit those crimes. This was an error on the court's part, but it was held to be of little significance. During his trial, Bittica admitted the assault on Malin. The jury found Bittica guilty of conspiring with Norris to kidnap women, specifying the Malin incident as an overt act done pursuant to the conspiracy. The Supreme Court stated, quote, "Under these circumstances, it is not reasonably possible that the failure of the court to give a reasonable doubt instruction affected the verdict." Bittica took issue with another thing you'll be shocked to hear, this time with the prosecutor's argument that the jury should impose the death penalty in his case to deter felons from murdering their victims. The Supreme Court was clear, such an argument is condemned. They explained that the argument addresses the minds of the jury to the deterrence of designated potential killers rather than the penalty to be adjudged to the defendants. The imposition of the death penalty thus rests upon the unproven and illegitimate assumption that it acts as a deterrent to the described potential killers. As we've seen with many of Bittica's proposed appeal grounds, the Supreme Court stated that this misconduct could have been dealt with at the time if Bittica's defense team had objected. The prosecutor argued that the death penalty was appropriate for each of the murders. He then commented without objection that the jurors should make a consistent finding on all of the murders because, quote, "You have a chance of having your wishes carried out, as this case goes through the appellate court, more if you are consistent in your findings." The US Supreme Court stated, quote, "It is constitutionally impermissible to rest a death sentence on a determination made by a sentencer who has been led to believe that the responsibility for determining the appropriateness of the defendant's death rests elsewhere." In court, it would be improper for the jury to return a death verdict with respect to one murder to protect the death verdict it returned for a different murder, and the prosecutor should not have suggested that the jury do so. The Supreme Court held that the prosecutor's comment was improper, but again, as defense counsel failed to object at the time, it couldn't amount to a ground of appeal. Looking back, I'm thinking I probably should have said, if you're not interested in law, or if you don't care about Bittica's proposed appeal grounds, then skip 20 minutes. But anyway, to be clear, on the 22nd of June 1989, Bittica's appeal was dismissed with the court ruling that any procedural errors were minor and did not affect the overall verdict. Bittica's initial execution date was set for the 29th of December 1989. For whatever reason, this did not go ahead. On the 11th of June 1990, Bittica appealed this decision, but the Supreme Court upheld the decision, meaning he would still be executed. His renewed execution date was set for the 23rd of July, 1991. Bittica appealed yet again and was granted another stay of execution on the 9th of July, 1991. Say what you want about this man, but boy, he doesn't give up. Whilst on death row, Bittica took part in a number of interviews. It was reported that he never expressed remorse for his crimes, saying that the only remorse he felt was for when he and Norris were arrested, because this was when his own life was ruined, and that alone, ladies and gentlemen, speaks volumes. Bittica did believe his life to have been wasted, but also considered it odd that he and Norris had very little in common before they met at California Men's Colony in 1977. He added that they had one hell of a lot in common now. Bittica continued to use the nickname Pliers whilst in prison. While incarcerated, he also filed more than 40 frivolous lawsuits. Yep, Bittica's complaining continues. He complained about stupid things like being served a broken cookie and crushed sandwiches, which he cited, believe it or not, as an example of his being subjected to cruel and unusual punishment. According to reports, Lawrence Bittica was declared a vexatious litigant in 1993. So, a vexatious litigant is someone who brings legal action solely to harass or subdue an adversary. Having been considered a vexatious litigant, Bittica was not allowed to file any lawsuits without the express permission of an attorney or a judge. So, what about the people involved in the Toolbox Killers case? Stephen Kay considered the murders to be the worst criminal case he had ever prosecuted or encountered. He recalled that for 2 years following the trial, he suffered with nightmares. Paul Bynum, who you'll recall he was the chief investigator, I'm really sad to say that he actually committed suicide in December 1987 at the age of 39. In his suicide note, Bynum did indeed refer to Norris and Bittica's crimes, describing them as haunting him, and of his fear that they might be released from prison one day. The recording of the attack of Shirley Lynette Ledford is now used to train and desensitize FBI agents to the raw reality of torture and murder. So, where are the Toolbox Killers now? Well, on the 19th of December 2019, whilst still incarcerated on death row at San Quentin State Prison, Lawrence Bittica died. He was 79 years old. His cause of death was recorded as being due to natural causes. Roy Norris was eligible for parole in 2009. However, he declined to attend his parole hearing for whatever reason, and so his parole eligibility was deferred for another 10 years. He was denied parole again in 2019. On the 24th of February 2020, Norris, who was incarcerated at the Richard J. Donovan Correctional Facility, died too of natural causes at the age of 72. Norris always maintained that the only reason he took part in the murders was because he was scared of Bittica. He claimed that he had considered going to police on 2 different occasions and claimed to have successfully deterred 3 potential victims from entering Bittica's van. He accepted that he enjoyed the intercourse, but that it was Bittica who enjoyed the torture and murder, saying, quote, "I didn't enjoy killing. That was Lawrence. It was his favourite part, watching the women struggle to live, knowing he'd soon be taking life away." Investigators and psychologists dispute this, stating that Norris did derive gratification from the domination, the abuse, and the torture, all of which harked back to Norris's extensive history of physical and sexual violence against women. And that's the end of today's episode. Thank you so much for joining me for this Halloween special. The Student's Verdict is a bi-weekly podcast, so please follow us on social media to hear about our next episode. The Student's Verdict can be found anywhere you listen to podcasts, including Spreaker, YouTube, and iHeartRadio. See you on the next one, and remember to keep living the dream. This episode is dedicated to Lucinda Lynn Schaefer, Andrea Joy Hall, Jackie Doris Gilliam, Jacqueline Leah Lamp, and Shirley Lynette Ledford.